agbanyeghị atụmatụ ọjọọ niile nke ndị iro iwe nye anyị ndụ ala nke dị ndụ n'ụbọchị nke taa anyị wee na-asị na ịja mma niile otu niile dịrị aha nsọ gị onye ọ bụ naanị aka ike niile na ọ gbadara aka ya anyị wee na-akpọku gị na-asị gị na nke ọma anyị ga-ekele gị nke ọjọọ ma anyị kelee gị anyị wee na-aja gị mma wee na-eto gị wee na-asọpụrụ gị n'isi ụmụ gị niile bụ ndị ikwu ndị wee ezi oku mgbe a kpọrọ ha ka ha wee chekwaa ala nsọ gị bụ Biafra onye nwe na Chineke na ihe ndị kwuru anyị nkwa na o mekataghị ka ndị iro wee were ala nsọ Biafra onye nwe na Chineke na nke dị n'igwe agbanyeghị atụmatụ ọjọọ niile nke ndị iro ma ndị na-agba mgbọgba ebe niile dị iche iche onye nwe na Chineke nna ihere bụ nke ndị dị etu a n'ụbọchị nke taa anyị wee na-eto gị wee na-asị onye nwe anyị na Chineke nna nke pụrụ m ihe niile onye ọ bụ naanị ya na-azọpụta onye ọ bụ naanị ya bụ okwu ya niile bụ ihe na amen anyị wee na-asị ezi ebube dị ngọzi na otuto na ịja mma na nsọpụrụ site n'ebighị ebi ma ruo n'ebighị ise ise ise.
A pending issue of secession or self-determination is determined. We have observed that a lot of some parts of the country are seeking self-determination. Some are even going about it violently, and to avoid that, we chose to go the civil way, the democratic way. The case was fixed for today. No, we're not supporting Biafra per se. What we are doing is saving the country and saving ourselves and the future of the country, because these people are becoming violent already. And most of the people engaged in this activity are below 50 years of age. So if we allow our leaders of today to go and leave us with these people in this situation, there may be another bloodshed or civil war. That is what we want to avoid, which is why we come to the court, is for the court to interpret the situation. We are not supporting anybody.
The court did not sit, as the judge is indisposed. He's out on official assignment. Hence, the matter was adjourned to 20th day of January 2022. I think we have already filed originating summons, and it contains our argument, our point of view, and in the wisdom of the court, we believe if it's listening to the provisions of the African Charter, particularly Article 20 of the African Charter, provide a right of self-determination. And Nigeria being a signatory to that charter, having ratified the provisions of the charter under our laws by the National Assembly, it becomes law, also operative in Nigeria as a member state. It's because of that we felt, as our clients approach us, that they want to seek for a solution to this issue. We say no, the solution is already there. Only that perhaps the actors have not averted their mind to that. The first thing to do in any civil society is to approach civil remedies first. Try to invoke the provisions of the charter. If for whatever reason people still have grievances, they resort to other means. But since there is a charter and Article 20 have allowed for any part of any country to seek for self-determination, we felt the right thing to do is to approach the court to interpret that particular provisions of the law. That's why we are coming under the originating summons, to interpret the provisions of the law and give effect to it. That is why, as the plaintiff, one of the plaintiffs is saying, we try to, we have a motion on notice. We decided not to come expected because we want all parties to respond to the motion on notice, seeking injunction to restrain the National Assembly from taking further steps with respect to this issue of a constitutional amendment. Because the argument is simple. Some people are saying they are not interested in the country. You are amending constitution to even create states in territories that are trying to say we are not interested in the marriage. So we felt the right thing to do is to ask the National Assembly to stop, in the overriding interest of the country, to address this issue. The issue of self-determination is not an issue of opinion. It's a general view of the people concerned. Everyone is a stakeholder, most especially in the areas that are interested in self-determination, you know, having their own country. Each and every adult member has a right to vote as to where his opinion lies. Because we keep having counter arguments, some saying we want to go, some saying no, we need presidency, some saying no, we want to stay, we are not part of this. The best way to get a general view on the matter is to allow people to express their rights under the law. Under the Constitution of Nigeria, there is no provisions to the best of our knowledge that allow for self-determination. But since Nigeria is a signatory is a member of the African Union, and then the African Charter is also binding by virtue of ratification, then we have no option than to seek that. That is the only legal remedy available to the best of our knowledge.
I am a party seeking to be joined, so I'm talking to you not in capacity of counsel, even though I'm a lawyer, but as a leader. And our leader is Chief Chuks, SAN, Ochia Orifite, who is unavoidably absent. So I speak in that capacity to say that today we came to ensure that we are joined as a party in the suit. Regrettably, the court did not sit. The matter has been adjourned to January. Why are we seeking to be joined? If a man is comfortably living in a house and somebody sues a third party to eject that man, it just behoves on that man a duty to apply to be joined so that he will be heard. And for us, we know that the African Charter of Human and People's Rights has adequate provisions on self-determination. And when we joined, we shall be seeking appropriate remedies to activate that section which is binding on Nigeria in order to ensure that a referendum is conducted. All we need to do is to amend the relevant laws. So we seek judicial order for that purpose. But ultimately, when we get to that bridge, we'll now file our counterclaim and seek proper reliefs. But what is important is that we cannot stand by and watch our fate being determined, because as Abiola said, you cannot shave a man's hair in his absence.
We are not afraid of the remedies being sought by the Northern elders. In fact, it is very, very wonderful that they are the ones now filing this suit, asking the Igbos to exit. Our worry is that they didn't join us, because when you want to make an application that affects a certain group of people, especially as a crucial, sensitive matter of this nature, you ought to join those people whom that kind of decision will affect, either positively or negatively. And that's the reason why my clients, are determined to be joined in this suit in order for the court to hear them. Because what these people are seeking for is capable of shaping the future of the generational people of the Southeast. That's number one. And number two, we have asked this question: why is the federal government afraid of referendum? Why is the federal government of Nigeria afraid of referendum? Referendum is not a call for war. Referendum is a call for peace. Peace. Let people determine where they want to be. When we are properly joined, we hope that the application we are asking for is a very harmless application, just to be joined. And we hope that the court will so do. And when that is done, and believe you me, we will file the necessary things, our own, whatever we have in mind to bring on board. And let the government know that we are for peace. Thank God, the people who say we should opt out of this country are the Northern elders. And we are saying that the government should accede to their request, especially referendum. Only maybe on certain amendments which the Igbo lawyers can bring on board and make it very, very amenable for the federal government to achieve that aim. The Senate President is part of the suit. The Speaker is a part of the suit. The National Assembly is a part of the suit. And the Attorney General of the Federation, very important, very, very important, is part of the suit. So they have the capability of persuading the National Assembly to do the needful. And you can see, let me say, this suit is capable of bringing peace to this country. This suit is capable of lowering the tension. You can see the killing going around the country. There's killing in the southeast, there's killing in the south-south, there's killing in the southwest, killing all over the country. This suit is capable of, bringing the desired peace that this country desires. When people have come together and say, let's reason together, let's see how we can cohabit together. Let's see how look. This suit is not automatically saying that the Southeast must leave this country. I must. Let it be very, very important. It's saying that let it be determined. The referendum can go either way. Scotland did it, England did it in Scotland. And the Scotland voted yes, want to be part of England. And today they are part of England. Referendum has been, this country has even had referendum. When the Southern Cameroon left this, it's through referendum that they joined the other part of Cameroon. When the Adamawa people joined, it's part of left the Cameroon and joined this country, it's part of referendum. So why is the federal government at this crucial moment afraid of referendum? The crucial moment in our national history. This nation has never bleeded as it is bleeding like this before. This nation is bleeding. And this suit, believe me, this suit, the federal government should be interested in this suit because this suit is capable of bringing the desired peace we need. When the people now come together and say, we want to be part of Nigeria, we are voting, want to be part of this country, and it is in their heart, it gives them the legitimacy, it gives our constitution the legitimacy.
Fight more, and there is no going back.
Win the war. Python that's one, Python that's two. Now Python that's a three. Unapoli Mary Nandi win the war. Python that's one, Python that's two. Now Python that's a three. Unapoli Mary Nandi bo onye do I fall. O Mary wone nizu Biroya Abakare Mamanda Ora Unapoli Mary Nandi win the war. Python that's one, Python that's two. Now Python that's a three. Unapoli Mary Nandi win the war. Python that's one, Python that's two. Now Python that's a three. Unapoli Mary Nandi.